Welcome to another episode on the Law Report, episode 27. Today I'm going to discuss the case of a police officer who had his conviction for theft in the magistrate courts overturned by the Supreme Court. On the 16th of January 2020, the officer was convicted of theft in the magistrate courts. On the 24th of March 2020, he was sentenced to 6 months imprisonment, suspended for 2 years. He immediately appealed to the Supreme Court on several grounds, contending that the evidence produced at his trial was insufficient on which to base or to found a conviction. Now, it is important to highlight these matters because when there's a conviction, it is plastered all over the media, the police issue press releases, and when the convictions are overturned, there is a wall of silence. I'll be back shortly to discuss the case, but before I do so, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact a lawyer of your choice. Welcome back. The case in a nutshell. The officer charged was Sergeant Grant, and he was charged under Section 3 of the Theft Ordinance. And Section 3 of the Theft Ordinance states that a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of that property. And Section 4, 5, 6, 7, and 8 describe or sets out what is the requirement for the elements of theft. So, for example, Section 4 describe what would be construed as dishonesty. Section 5 sets out what would be construed as appropriation. Section 6 describe what is property. Section 7 sets out what the term belonging to another means, and Section 8 sets out intention to permanently deprive, what would be required to establish an intention to permanently deprive another of property. The Crown's case at trial was that sometime in 2017, 20th of December, thereabout, that Sergeant Grant found a purse at IGA Gourmet supermarket parking lot in the Grace Bay area. That the purse was the property of a Filipino lady residing in the Turks and Caicos Islands, that she accidentally dropped this purse, that it contained cards, bank cards, and a quantity or a sum of money. That Sergeant Grant never handed over the purse to the police until 9 days after he found the purse. That the police contacted him, that he acknowledged that he had the purse, but stated that there was no money in the purse when he found it, but took 9 days to hand it over. And that view of the Crown's evidence, they thought it was sufficient to found a conviction. The defense case at trial in response was one, that there was no money in the purse. There are two, that Sergeant Grant was the one who volunteered that he had the purse, that he found the purse. That three, the police always knew that he had the purse. 4, that there was no money in the purse. And 5, the reason why he didn't hand it over immediately is because he had misplaced the purse. Now, in my respectful view, and an initial examination of those facts, someone may say that there is something suspicious. But the question is, does it rise to criminality, and could it meet the high threshold so that a trial of those facts could be satisfied as to be sure to the criminal standard of beyond reasonable doubt that Sergeant Grant's appropriation of the purse was dishonest, and further that he had the intention to permanently deprive the owner of the purse and contents. The defense at trial contends that the matter did not meet the threshold. And in my respectful view, if this matter was dealt with internally through the police disciplinary mechanisms, it is quite likely that Sergeant Grant may have been convicted in a disciplinary hearing and may have properly lost his job. But in a criminal case, that's another matter. During the trial, it also emerged from one of the witnesses for the Crown, a close friend of the person who lost or who dropped the purse accidentally, that in January, almost a month after the virtual complainant lost her purse, that both parties were at their workplace and the Philippine lady had a sum of money in her purse. Now the Crown case was that the money that was in the purse was monies that was repaid as part of a loan by this friend to the virtual complainant. But the friend testified that after the Filipino lady lost the purse, they were at work and she had a quantity of a large sum of money in her purse, and he advised her to put the money in the bank. He asked her what was she doing with that large quantity of funds, and she told him that she still had the money that he repaid her. Now this is a stunning development, because the Crown's case was that that money that was repaid by this friend to the virtual complainant was the money that was lost in the purse and the money that Mr. Grant was charged for stealing. But here there was evidence at trial from this friend that he was told by the virtual complainant that in essence she still had the money that she was claiming to have been stolen. Now, the magistrate at trial seems unmoved, unimpressed by this evidence, which clearly undermines the Crown's case. The magistrate went on to convict Mr. Grant, and in the decision setting out the reasons for his conviction, there was no mention of the evidence at all of the witness who the Crown relied on and who undermined the Crown case in such a fundamental way that the defense submitted that the judge or the magistrate could not be satisfied as to be sure that there was one, the monies in the purse, and secondly, that there was a dishonest appropriation or an intention to permanently deprive, when from the very inception Mr. Grant was the one who volunteered the information that he had the purse and that the police always knew where the purse was. The appeal was heard on the 20th of December 2021 in the Supreme Court. I'll be back shortly to deal with the decision of the Supreme Court. At paragraph 10, the court dealt with the grounds of appeal. Paragraph 10 continuing all the way to paragraph 20. Paragraph 10. The first ground of appeal is that the conviction cannot be supported having regard to the totality of the evidence. In support of this ground, counsel for the appellant says that at the trial, the complainant said that when the purse was lost, she had, in addition to cards, cash amounting to $3,000, more or less. This sum comprised $2,100 or so that she had been reimbursed by her friend, plus other funds she said she had in the purse at the time. However, counsel for the defense or for the applicant draws attention to that part of the friend's evidence where he says that sometime after the 2nd of January 2018, whilst at work, upon noticing the complainant opening her purse, he asked her if she still had the money that he had repaid her, and she replied in the affirmative. He then asked her why she had not taken it to the bank, and she replied to the effect that she had been too busy at work during the holidays. Counsel for the appellant makes the point that this completely undercut the prosecution's case, as there been money in the purse, and if so, how much? Paragraph 12. In response to this point, the learned prosecutor, the Deputy Director of Public Prosecution, takes the confession and avoidance approach. She concedes that the friend gave such evidence, but she attributes this to his being confused. And she says that having heard the evidence, it was for the court to assess whether he understood the questions put to him and the veracity of his answers. Paragraph 13. According to the transcripts before me, the learned Chief Magistrate dealt with the matter not in her judgment, as the learned prosecutor indicates at paragraph 6 of her response, but in an exchange with counsel for the appellant after the decision had been pronounced. She said this, and I do recall that the witness was going in sore clothes in cross-examination, but I don't recall him being in sore clothes in relation to the payments that he gave her, which dates he gave her, and how much he gave her. But with respect to both the learned Chief Magistrate and the Deputy Director of Public Prosecutions, I do not believe that was the point counsel for the appellant was making, or in any case the point that needs to be made. And as I understand the evidence, it seems to me that counsels for the appellant concerns was directed not to payments that the friend made and the dates he made them, but to that portion of his evidence where he said that sometime after the 2nd of January, when he saw the virtual complainant open her purse at work, he asked her if she still had the money he had given her, and she said she did. He asked her why she did not take it to the bank, and she responded that she was too busy at work all during the holidays. Paragraph 15. My assessment is that counsel for the appellant was right to call attention to this chink in the armor of the prosecution, as clearly, if true, it ran counter to the case being advanced that the complainant had that money in her purse when she lost her purse on the 20th of December 2017. It undercuts the prosecution case and the charge in an irreparable way, and casts doubts on the veracity of the versions of events advanced by the virtual complainant. And it has not been answered in any satisfactory way. In my judgment, it renders the conviction unsafe and unsatisfactory, and I therefore allow this ground of appeal for that reason. Now, the court did go on to examine other grounds. For example, the court at paragraph 17 states, the second ground of appeal is that the Chief Magistrate failed to have any sufficient regard to the inconsistencies in the Crown's case. In support of this ground, counsel for the appellant note that the complainant did not mention money being in her purse when she initially reported the matter to the police. It was only when the police responded to the report she mentioned money, and at that time she said it had $2,000. This was repeated in 3 witness statements, and it was only a trial in her evidence that she mentioned $3,000. Given these inconsistencies, the prosecution felt compelled to seek an amendment to the particulars of the charge to read that the virtual complainant had cash exceeding $2,000 but not exceeding $3,000 in a matter that had commenced on the basis that the purse contained $2,000 when it was lost. Counsel for the appellant identifies as the high watermark of inconsistencies in the prosecution's case, the discrepancies between the complainant's contention that money given to her by her friend was in the purse when she lost it, and the evidence of that friend that she indicated to him in January that she still had the money. He had repaid her. In response, the Deputy Director of Public Prosecution dealt with both grounds 1 and 2 together. In relation to this ground 2 specifically, there does not appear to be any direct reply that I can disown over her paragraphs 18 to 16. I also do not see any note of the Lorne Chief Magistrate in her judgment expressly directing herself to the inconsistencies of which counsel for the appellant complains and how she resolved them. Again, therefore, I hold with counsel for the appellant that the defendant might well have been deprived of a fair trial, and that applying the standards of instructions to a jury, the conviction is unsafe and unsatisfactory, and it should not stand. At paragraph 25, the court had a discussion on the issues. At paragraph 26, the court states, the delay in surrendering the purse and the necessity for the police to have to attend the appellant's house to collect it reflects very badly on the appellant, and by association and his employers, the Royal Turks and Caicos and the police force as an institution. It might well have been a career-ending infraction of their internal rules. And that is the point that I was making earlier, that had this matter been dealt with internally, it is possible that Mr. Grant may have been found to be in breach of the police force internal rules and may have been properly dismissed. At paragraph 28, the court states, in the circumstances and for the reasons given at paragraph 16 and 20 above, I allow the appeal and I quash the conviction and sentence. And there you have it, viewers. Sergeant Grant's conviction was overturned, and he now stands before society and before the law as an innocent person, a person of good character. And I thought that it was important for me to discuss this case, because in most cases when the conviction is overturned, there are little or no discussion on the matter in the public domain. Here is where I will leave it for today. I welcome your comments, and I will see you in another episode. Thank you.